Remedies, IDERA, and default planning. Hello, yet again. This is Forrest Owens. I'm an aviation lawyer, a private pilot, and an FAA licensed airframe and power plant mechanic. Finally, let's discuss the issues clients feel most sharply when a deal goes bad. Remedies, IDERA, and default planning. The Cape Town system can be powerful, not because it produces elegant filings, but because those filings are tied to remedies. The Aircraft's Protocol Article XIII addresses the Irrevocable Deregistration and Export Request Authorization, or IDERA, where the debtor issues an IDERA in the required form and it is recorded when with the registry authority, and the authorized party becomes the sole person entitled to exercise the specific deregistration and export remedies, subject to applicable aviation safety laws and regulations. In the United States, those treaty concepts are carried into FAA practice. The FAA explains the Cape Town framework establishes the right for owners of eligible aircraft to grant an IDERA to a secured party. Under 14 CFR section 47.47, if an aircraft is subject to the Cape Town Treaty and an IDERA is filed, the FAA will honor a cancellation for export request only if the authorized party makes the request and certifies that all registered interests ranking ahead of it have been discharged or have consented. This is a crucial practical point. An IDERA is not a magic wand. It is a priority-sensitive remedy. The requesting party must still deal with senior registered interests. So the creditor who assumes the filing of an IDERA alone guarantees a clean export is misunderstanding the structure. The treaty helps the secured party, but it does not erase the ranking order the registry itself created. The protocol also addresses insolvency. Article 11 provides insolvency remedies where the relevant contracting state has made the proper declaration, including Alternative A, which requires the insolvency administrator or debtor to give possession of the aircraft object to the creditor no later than the end of the waiting period unless defaults are cured and future obligations are agreed to be performed. For lenders and lessors, that is one of the most commercially important features of the Cape Town system. A modern example of why timing and aircraft lease remedies matter, Aviation Holdings SA, decided by the Second Circuit on February 3rd, 2025. That case was not a pure international registry priority dispute, but it shows how quickly aircraft financing rights can be litigated when a debtor enters insolvency. The court held that payment obligations under aircraft leases arose when they came due, not when the leases were originally executed. The lesson for owners, lessors, and creditors is that in an aircraft insolvency, timing, documentation, and remedy structure are not academic. They will determine later leverage. There is also a practical export lesson hidden inside the FAA process. When an IDERA authorized party seeks cancellation for export, the FAA requires an international registry search certificate and proof that higher priority registered interests have been discharged or have consented. In other words, when default arrives, the search results become part of the remedy file. And that is why it's recommended that clients' search should not be treated as a one-time pre-closing exercise. It is part of the life cycle of the asset. For private aircraft planning, from a private aircraft planning standpoint, the right approach is to build the default file before any default occurs. And that means confirming treaty eligibility, obtaining the correct entry point authorization, registering the correct interest, recording sale registrations when appropriate, filing and recording any IDERA needed for the filing structure, mapping discharge authority, and preserving a complete copy of the search certificates and consent chain. There's another issue that deserves emphasis for owner clients. The International Registry protects priority, but it does not resolve every operational or local law issue. Aviation safety rules still matter, local court procedures still matter, export and customs issues still matter, and in some jurisdictions, the value of Cape Town remedies depend heavily on the declaration that state has made under the convention and protocol. So the right question is not simply, did we register? The right question is, did we register in a structure that will work under pressure in the relevant jurisdiction after default? I'd like you to take this away and remember this. The best time to plan for your aircraft remedy is before you need your aircraft remedy. When registration strategy is done well, it gives owners, lenders, and lessors a language of priority and a pathway to enforcement that can be understood across borders. But when it's done poorly, the parties discover too late that they have documents without leverage, filings without coordination, or remedies blocked by a superior interest that should have been addressed before closing. In short, the International Registry is where transaction planning meets enforcement reality. It's not glamorous and arguably not optional. And in a distressed aircraft transaction is often one of the first places where this outcome begins to tilt. I'd like you to take this away. In aircraft ownership and finance, the International Registry is not just about filing first. It's about being able to act first when the deal breaks down. Thank you again for your interest in this topic. This information is provided for informational purposes only. It should not be construed as legal advice. Questions? They're always welcome. Please direct them to admin@aviationlegalcounsel.com. We look forward to hearing from you and helping you navigate your aviation-related legal needs.